All right, I think next we have, Keith, do you want to elaborate real quick on what you do as a chief chaplain that kind of ties into some things we're trying to do?
We have the purpose of the chaplain program, first of all, is to be supportive of our law enforcement personnel and their families. So we're available for counseling and ministering to them as that may need be. But along with that, as we get involved with them, then we end up working with community members in a variety of situations. One of our chaplains lives here in Happy Camp, that's Stan Paschal, and he's part of our chaplain program. I have been to Happy Camp the last 15 years. I've been to Happy Camp more than any other place in the county, partially because of when you have the fires out here and you have the helicopters go down and you have other accidents. We bring a team out and do some critical incident debriefing. Karina Walters back there is part of our team, and she's now working a lot out here in Happy Camp as well. So we provide that critical incident debriefing for all first responders. I know most of your fire people quite well because I've spent a lot of time with them. And that's how we assist. One of the things we do with law enforcement is go out and help them with their death notifications. And you heard about the committed athlete program, the other committed program, and one of the hard things about that is just a couple weeks ago I had to go with a deputy and make a death notification to a mother whose 21-year-old son made a bad choice and was killed in an automobile accident. And kids don't know how hard that is. That's one of the toughest things I have to do because we just have to spend that time with those parents. I get involved with the every 15-minute programs. A couple weeks ago I was down over in Doris. And so chaplains are involved in a variety of ways, just to be helpful, to be an encouragement, to help people stay healthy mentally after critical incidents, and we enjoy being part of the law enforcement family.
Thank you, Keith. Next we're going to hear from District Attorney Kirk Andrus. Kirk, you ready?
Thanks, Sheriff. So, you've already heard from me tonight on another subject. So what I'd like to do, my office, as you probably know, we are a reactionary office. We react when things happen. We file lawsuits on behalf of the people of the state of California, my constituency, and file criminal cases and try to enforce the things that our fine law enforcement officers bring to us from the streets. So I'm just here to support this effort. I am mainly here to hear what concerns there might be, and I'm happy to answer any questions. That's mainly what I want to do right now, answer questions. So any questions for me? Yes, ma'am.
Could you expand on the public nuisance lawsuits or the public nuisance ordinance that's coming out in terms of nuisance property owners that have, say, hazards, burned out buildings, old cars, dogs, overflowing trash, marijuana, things like that? How is the DEA going to address those issues?
That's a great question. Is that because you've seen some of those recently, or because you'd like to see enforcement in some areas?
Attribute to that. Directly across from high school, a coach and family man, we have 2 children that were in high school. A building burned directly across from the entrance to the high school. It was a public nuisance, and it is still there. It's in danger of collapsing. Nothing has been done. And we take that as an example to the children and the programs, the fine programs these people are putting forward. You take your children and pick them up from high school, and that's what they see. That's not the right message to be sending. What's being done, what could be done outside of code enforcement.
Well, I don't know about outside of code enforcement. I mean, has anybody called the county to let them know about that?
Oh, yeah.
Because I've never heard of it before.
I'm sure the high school has taken an active role in that.
Okay. Those are good things to know. There are kind of 2 answers to that question. I mean, number 1, and you're not talking about the ordinance that the sheriff was just talking about, the marijuana, right? You're talking about nuisance abatement, like the kind of thing this gentleman is talking about.
from what I understand, aren't the ordinances actually tied together? The public nuisance ordinances for marijuana is also tied in with the ordinances for burned out buildings, overflowing, trash, hazards,
Sure.
that kind of thing. The code enforcement officer who's going out to also address the marijuana issue is also going out to look at, say, cars that are next to the creek that have the oils and runoff, and it's running into water systems, et cetera. It's the same officer, is that correct?
Yes, I mean, and the challenge in the past has been, Siskiyou County laid off their code enforcement officer about 5 years ago. So there has been nobody in this entire county whose job it is to do that job until now. And the motivation for the county to hire a code enforcement officer has been around this marijuana ordinance. So, I'm hoping and expect that a code enforcement officer is going to enforce all the codes and not just this one. A more specific answer to your question is, my office actually last year applied for a grant to the Attorney General's office to literally do civil abatement. I wish I had known about this one. I mean, if you're on I-5 and you're driving south and you go through Dunsmuir, that old abandoned hotel up on the left? There's a pool sitting right there? Does anybody see what's around the pool right now? Well, there's something. It's a big yellow protective fence because we sued them. Right, it wasn't there before. Because my office sued them to abate that danger to children. And we've got a lot of those things going on right now in Wairika. As we hear about these things from the public, I have an attorney who I've hired through this grant to bring civil abatement cases, and we're actively pursuing those right now. We've got some really good success. The problem is, you follow the money. This is something we've wanted to do for a long time. We've been able to do it for this fiscal year, and it ends June 30th. And we've called the Attorney General and said, look at all these great successes we're having. And they say, I'm sorry, there is no more money in this program. It's not that you can apply, it's we wanted to do this one time so our Attorney General, Kamala Harris, could talk about how great she is when she runs for Senate. So we are not going to have an attorney be able to file lawsuits to do civil abatement after this year. At least not anybody who's specifically assigned to doing that all the time as their job. But as we find things like this out, I've got enough attorneys on my staff that we can abate these problems. The problem is there hasn't been anybody on the street to bring the reports to us. So I'm thinking this is going to be a new era for problems like that.
So what's the process for that? So say, someone is growing marijuana from the DA's perspective, or say someone has, runoff that's running into the creek and it's cars or what have you. What's the process for the property owners? What does that look like?
Well, the process is to contact the appropriate agency who would have an investigative officer, in this case a code enforcement officer. They would investigate it, document their findings, send it to us. It's two separate questions though when you're talking about civil nuisance abatement and when you're talking about marijuana. There's not a penal code on the civil nuisance abatement. It's not, you can't lose your freedom over that. When we file lawsuits against somebody, it's to get a court order for them to cure the problem or to make them pay money. That's what a civil lawsuit's all about. It's about money or it's about making people do something under a court order. It's not about going to jail. Marijuana is on the books in the Health and Safety Code as a crime under some circumstances. This code enforcement effort under the county ordinance is an opportunity to go in and abate and change the problem with code enforcement officers with law enforcement backup. We expect that this ordinance is going to allow them to solve problems, not necessarily to bring us civil lawsuits. There's really no purpose for it. If a code enforcement officer with law enforcement backup can go in and solve the problem, close a garden, take down the plants, there's nothing for us to file a lawsuit about to civilly abate. Now, if it turns out they're breaking the law, that's what we do every day. We could always file a criminal lawsuit.
So if you have a property that's overrun with trash and is a typical drug house, it's unkept, and there's hazards in the yard, and they're white powder users, whatever that is, and a neighbor calls up and says, I would like to have this looked at as a public nuisance, the code enforcement officer rolls in, and then you guys are on site, and you can take a look at that issue, and from that point on, would you pursue it as a criminal investigation, you know, for the white powder drugs?
Well, you've got a member of the Narcotics Task Force who's in the building tonight. I would think they would be involved in that conversation. If that's something that could develop itself into a drug case, that's what we do every day. We have staff in place for that. We've got a task force. I've got a prosecutor who's full-time assigned to those cases. They absolutely know how to handle that business. If you're talking about the first part of your question, which is rundown, overgrown, health hazard, the code enforcement officer can either abate that on scene, on site, or they can generate a report and send it to us, and we can do civil enforcement action. So that's the way it would work. Those are great questions. This gentleman has something to add.
It's the same place. It was burned out, and the floors are dangerously weakened. So I can see some kid walking out too far very easily, and they can walk straight off the street into this. Every day Margaret and I we walk by that.
How long has it been that way? I mean, how long has it been burned out?
6 months. 6 months. Well, 6 months at least, and it's within 50 feet of the entrance of the high school.
This is, I mean, I feel terrible saying this. I mean, we've got until June 30th that I have staff to deal with this. But we actually hired an investigator. He's kind of a code enforcement officer of my own. And he's literally been on the job for 2 weeks, and he's got till June 30th, and then he's unemployed. I'll send him back here. On that call, I'll send it back. I hadn't heard that before. Yes, sir.
Related, unrelated question. There's a historical building in town. It's a mercantile building. It was involved in whatever, I'm not sure, related something or another. However, we noticed that there was graffiti and translated on the Urban Dictionary, it's gangsters, disciples, gangster, disciple, killers, meth lab in use, and there's another one that says No Flex Song, which is a rap song. Is there gang activity in Happy Camp?
Oh, yeah. I think that's probably a good question for Sergeant Callahan, you know, or some others who are here on the streets every day. But from our perspective, absolutely. In the DA's office, I've got a prosecutor assigned to the gang cases, and our job is to identify the cases that come to us that have documented gang activity, and we have done that in every community in Siskiyou County. The way we can get enhancements and prison sentences is to document that gangs exist, that crimes are tied into those gangs, and identify who those individuals are. The jail does a very good job at intake to get that information. Ironically, at a time like that, it's in the crook's best interest to identify themselves with their gang monikers and also with their affiliations, because if they get housed in the wrong place in the jail, they could have a big problem. So that's a time when they want to come clean. And the sheriff's institutions right there in the jail identifies those for us very well. And they're here. They're absolutely here. Yes, sir.
As a minor, I'd like to get a hypothetical. Both the federal and the state court have declared that dredging or prohibition of dredging has been declared illegal by the state law. The fishing game commission are now arresting people and taking their equipment while they're dredging in the rivers and the streams. Since it has been declared illegal and these arrests have been made, is it possible that a citizen's arrest of the fishing game warden would be practical and within the law as theft of the equipment?
That's a very insightful question. In my opinion, the answer is absolutely not. And this is not a philosophical answer. Philosophically, I would probably lean the other way. But I organized a rural county DA's conference a few months ago, and the person who's putting together the agenda invited Fish and Game to come. And when they were talking to the rural county DAs, it's not like being in Sacramento and talking to legislators. You know, we're not necessarily a friendly group to some of the enforcement practices. And so we discussed that very question. And from my perspective, they're on solid ground in looking at that case, seeing that in one of the Southern California appellate districts, the law was found to be unconstitutional for obviously reasons associated with an ability of a human being to mine on a scale such as that, and a well-reasoned decision. That decision was unpublished and being appealed to the Supreme Court in California. And during that time frame, that law, as a technical matter, or that court case, I'm sorry, as a technical matter, is not enforceable in this county and isn't necessarily enforceable anywhere in the state. So the law is still on the books. There's just a situation where it's going to get clarification from the Supreme Court one way or the other. It's absolutely going to happen. In the meantime, they have a law that they can enforce, and they're not violating the law in doing so. It's a very challenging situation.
And it only comes down because I believe most of the local wardens don't like it anyway. Don't like
Agreed.
to enforce it.
Agreed. That's a very insightful hypothetical, I think, and that's my honest take on it. I kind of, frankly, wish my answer was a little different.
Well, could I get some clarification on that? Because Judge Ochoa's ruling is wonderful. What went to the California Supreme Court, totally different citation.
And
That's the
Judge
very
Ochoa
one-
is where?
Judge Ochoa is San Bernardino. He's the one that ruled that it was illegal, unconstitutional, unenforceable as a fact of law. What went to the Supreme Court was Brandon Reinhardt's decision saying that you either need to drop it or let him have a trial. And the state appealed that to the Supreme Court. Not Judge Ochoa's ruling. That was published and did not go to the Supreme Court.
Well, and I was kind of mixing those two into one. Judge Ochoa's ruling is in another district, which is not enforceable in any other district. If I were trying to prove a case, and an appellate court down in San Bernardino had made a decision that was friendly to me, I could put it in my legal briefs here in Siskiyou County to show the court, look, this person was being very reasonable in their decision, but what that judge said is not binding in Siskiyou County. Because it's a
Okay, then
different
why did
appellate
they
district.
pull up all of our cases from Siskiyou County to that county?
Because they don't have jurisdiction over our cases. That's why the California Supreme Court is so important, because they have jurisdiction over the whole state.
But it's still two different cases.
Yeah, I agree with that. They are two different cases. I was kind of melding the situation a little bit, but I mean, the bottom line is outside of that, out of the appellate district, those cases are not binding on our judges.
Okay, then good, quick question then.
Sure.
We had the opportunity a couple weeks ago to have it settled in this county. We had a guy that was arrested twice, refused to be discharged from jail because he wanted his day in court as of the 6th Amendment. And he was pushed out. Nope, you ain't got no room, you can't see a judge. Well, you know.
Yes,
So
I do.
why? If you don't mind me asking.
It's fine. Well, it's kind of fine. I mean, I can't comment on the current case, but I can give some direction. Why what?
Why was he refused the chance to see a judge to get an answer?
Okay, I'm going to have to assume that some people in this room are going to be familiar with this case, and I can talk about it just kind of generally.
Well, that's why you give that.
Yeah, no, it's fine. He was released from jail because of the reasons that the sheriff talked about earlier, which is that there's no room in the jail. The bottom line was, we're going into a weekend. Sheriff Lopey and I had a conversation. There were no people in the jail charged with misdemeanors. 0. Well, there was one, and it was him. He was the only one. Asking to remain in jail for that situation is creating a really significant civil problem. I mean, if he has a health problem in there, or gets beat up because he's in there with a bunch of felons who are just like a bunch of people in state prison, just because someone wants to make a point,
That's not a point.
well, no, it is a point, and I'm not saying it's a wrong point. I'm just saying we can't leave one person in there and treat him differently than everybody else. And that was a space in the jail issue. The second part of that was his attorney said, why don't you just stipulate that he is in jail, even though he's not, and he can have his day in court. Okay, that makes sense, right? You know what the problem with that is? What happens when the Attorney General sees that and looks at Siskiyou County and says, so they're stipulating that someone who is home in their kitchen is in jail just so they can challenge this law, that's a county that we can't trust. That's a county that is leaning the other way, which means the Attorney General then comes in here and prosecutes all those cases because we're too friendly to one side than the other and they're not remaining objective. There are too many problems with that situation, and there is a very real threat to our sovereignty if we don't follow the law. The Constitution gives this county sovereignty. Part of that sovereignty is in the position of the sheriff, which appears in the Constitution of the state of California. Part of that sovereignty is in the position of the district attorney, which appears in the Constitution for the state of California. We are not going to sacrifice our sovereignty by skipping legal steps that could cause the state to come in here and take over enforcement. We're going to be fair, we're going to be objective, we're going to take the cases as they come and follow the law. But we can't treat somebody different from somebody else. It threatens everything that we have to
I
enforce.
understand that, but like last year, we had equipment taken, just the receipt left. And, oh, well, we've got 12 months to, investigate this. We haven't heard nothing.
Has it been more than 12 months?
It's almost 12 months now, we haven't heard a word.
I guess keep your ears peeled because there's a 1-year statute of limitation on those cases.
Yeah, but why are they allowed to come and take your equipment and not even file charges?
Well, those would be questions for the state agency. And just to be clear, if they take equipment and if they take a case, the one who filed charges is either my office or the office of the Attorney General. I've got 2 calls from the Attorney General in my inbox right now that I haven't returned about this subject. So I don't know what's coming up next. I can only control what we can control in our office. Yes, sir.
Since you're pretty close to the judicial system here and what their budget is, what about having a probation officer down the river, or at least some probation officer that goes back and forth?
We've got 2 supervising probation officers here. Why don't we defer that question to them? Amy, Lee, either one of you?
Hi, I'm Amy Fernandez. I'm with the Adult Probation Department and police juvenile. And your question was, why do we have a probation officer stationed in Happy Camp?
Or one that varies his office downriver?
Well, just to give you a little bit of background, we have almost 700 probationers on probation, and up until April 1st, our caseloads were incredibly high. As of April 1st, though, we are down to caseloads of approximately 50 people per officer, which is a much more manageable caseload. We're also supervising people on a risk need level, which means that we are identifying what their risk is to reoffend and trying to divert services to them so that we can address their criminogenic needs, which are those needs that increase their likelihood of reoffending. So the hope is that we can address those needs and reduce their risk of reoffending. We don't want them to go back and continue to use drugs. We don't want them to continue to commit crimes. So that's what our goal is. Since April 1st was 6 weeks ago, we have instilled an expectation of our officers that they will see their probationers in the home at least once. We have 35 probationers in Happy Camp. It is hoped that that expectation will be met in the upcoming months, starting this month. So, whereas we simply can't put a probation officer in Happy Camp when we have just 35 individuals on probation, but we can try to get into the home as much as possible, and that's our goal.
What about Horse Creek all the way down to Sutton? I mean, that's a whole large area, and I'm sure you got more than 35.
So again, we're trying to supervise people according to risk need. Now, when I say we have 35 probationers, that doesn't mean we have 35 high-risk offenders that need to be seen in the home every month. It simply means that we have 35 probationers. And so 25 of those 35 may be low-risk offenders. And because we have such limited resources, we don't want to, sorry for the word, but waste our resources on those low-risk offenders. We need to make sure that we're putting all of our resources, all of our attention on those high-risk offenders. Those are the ones that, you could identify probably out in the community who might our high-risk offenders be. And so between Forest Creek to Happy Camp, I'm not sure that we would have enough high-risk offenders in order to justify that. But that is something we could look at as far as creating a caseload geographically.
The reason for my question was that I've ridden into Puerto Rico on the bus a couple of times with them, and they've got twice a week visits. And that takes 2 days a week out of their working availability to even pay their probation fee. That's kind of expensive for me.
Well, for probationers, I'm not sure what specific individual it is that you're referring to that has to come out to probation twice a week. A lot of times they might be a drug court. They may be participating in services for child protective services to try to get reunification accomplished. We do provide bus passes for them, and if an individual, I know I can speak for myself, if an individual is gainfully employed, I'm not going to be requiring them to come out to my office twice a week. Chances are the individual isn't gainfully employed, and it's better for them to be coming out and complying with their terms than to be sitting home not addressing their needs.
Of course, in Happy Camp, it's probably most people that aren't employed.
Of course. Any other questions?
Just so you guys know, we had 2 officers from my unit. I only have 3 officers in my unit, and then we'll go down to 2 at this point. And 2 officers were in Happy Camp last week, and they were here most of the day. So it is a priority for us. We do really care about your community. I live in a somewhat high-risk neighborhood in Siskiyou County, and I can relate to some of your concerns, and we do want to have a timely response, and we encourage you to call us and let us know what's going on. And we try to focus on the families in general and not just the specific offender, because it's really bigger than that. What is the resources available to them, and what is the networking that's available to them? And so we do appreciate you guys inviting us and having us here, because that's really important for us to be involved in this.
And just to piggyback on that, we do appreciate the phone calls, even if they're anonymous, even if you don't know if the individual's on probation, please feel free to call us, and we can, if they are on probation, we can refer them to the appropriate officer so that action can be taken.
Thank you.
So Lee and Amy are a tremendous resource. They do a great job, and if you have questions or information about a specific probationer, the fact that they're here is a great opportunity. Other questions for me? Yes, ma'am.
Just a quick comment. I've been working with the tribe for the last 2 months now, full time. And coming down to Happy Camp, I wanted to thank the officers too that we've worked with. We've utilized them, and they came promptly and handled the situation. It was a very high-risk situation. They did a great job, and it was a very frustrating situation. And just cool, calm, and collected. Very good job.
Sure, appreciate you saying that. Thank you. I will just leave it at this. These questions and others on any subject, including information about cases that we may have, wondering where cases are that you hope that we will file and prosecute, please call me. I really welcome those phone calls. Call the DA's office, ask for the boss. I'm easy to find, and I hope to have some of those conversations with you. I appreciate you asking me frank questions tonight. This is how we get things accomplished. Anything else for me? Yes, sir.
I don't understand how somebody has a federally granted right to work a mining claim, but a state agency will still come out, harass and intimidate you, when judges have ruled that it's unlawful and unenforceable. I still just don't get that. And we can't get any due process or any relief.
We can't see a judge. And every time we do, like when we was gonna file for a restraining order against the person, it gets pulled down to San Bernardino. Instead of a normal thing, it's, well, in 45 days, we'll let the state argue it. What? How is that relief in any fact, shape, or form? We are getting zero due process as minors.
I don't disagree with you. And the interesting catch-22 that I'm in, and I'll tell you, for those of you who aren't familiar with the issues these gentlemen are talking about, and other gentlemen have touched on, They are very, very complex. And the reason they're complex, you've got federal and state preemption issues about the law, and those issues are settled. I mean, they've been litigated. The state can have laws in this area, and they can enforce them. And there's nothing we can do about that. So when you're looking for an injunction, the court system has almost no resources to hear cases like that. So you get pushed way down the road. And so what has kind of happened is everybody has asked for me to make the decision. In order to make the decision, I've got to charge a minor with a crime, okay? So I'm not going to do something I don't believe in. So I'm not sitting here saying how I'm going to rule on cases or decide cases that come to me in the future, you know? But I will tell you that. I'm not going to charge someone with a crime I don't believe in just to get an answer. I would consider that to be an unethical thing for me to do.
I actually appreciate that, I really do, but it's still the fact that they're gonna steal the equipment, and then they have 12 months to not do nothing before you, even if you get it back in one piece.
Well, the good news is you've got the California Supreme Court who's agreed to make a decision. And these aren't judges, these are justices, meaning every word they write impacts every inch of California. So you're going to have an answer. It's not satisfying today because that answer is probably going to be 2 years from now.
Well, see, and that's the thing, we've
I-
waited 6 years already.
I agree.
And I owning a business here, you know, we're waiting. I mean,
Yeah.
my summer depends on these miners coming, and I get all these reservations, and then they throw it all out again, and then everybody's going, well, sorry, we're not coming this year. So we're struggling out here. This is-
I think there's probably
Rich.
gonna be some resolution come June 23rd in Judge Court. All the paperwork has been filed by our attorney to PLP. Obviously, the state will respond to that, and we'll have one last chance to respond to their decisions. Answer at least on June 23rd.
Well, I understand that, he just said that that court has no opinion over the state.
Well, but it could change the state's practices.
Yes.
It absolutely could change the state's practices. If they see that that's going somewhere and feel like they can spread appellate district to appellate district across California, they're not going to apportion their resources in that area. But you know, that's up to them. But that would be a huge step in the right direction for minors. There's no question about that.
So there's a good possibility we could have another 2 years, and that would put over, what, 13 years in litigation over this?
If you're waiting for the Supreme Court, it could take.
We're just waiting to go back to work. We're
I
going
think
hungry.
the answer is going to be coming for what we need on June 23rd.
And we were told that last month, and we were told that 4 months ago, and 6
But
months
we
ago.
know that for a fact now.
No, we don't.
Any other questions for me? These are definitely challenging issues. Anyway, I appreciate your time tonight. Thanks.
Thank you, Kirk. I know everybody's been sitting a long time. You want to plod through, or you need a 5-minute break?